Hi, I'm Brent Van Deysen. As an elder law attorney, my law firm is dedicated to helping seniors protect their property and their life savings from the high cost of nursing home care. My law firm helps seniors qualify for governmental benefits to pay for nursing home care, in-home care, and assisted living care. We can ensure that your life savings will benefit you and your loved ones, not the nursing home or the government. Call for a free consultation at 304-594-1900.
It starts with something little, like taking a first step, and then another, and another. And if you do it, and your friends do it, and their friends do it, soon we'll be walking our way to awareness, support, and an end to Alzheimer's disease. And that would be big.
Grab your friends and family and start a team today. Register at alz.org.
Hello and welcome to Network West Virginia's Legally Speaking. This program is designed to educate and inform you, our local viewers, about the legal practice in our great state and how the law can affect you. Each week on Network West Virginia's Legally Speaking, we will feature some of the most progressive attorneys in the state, and you'll hear direct from them on a wide range of issues. You'll also be able to ask questions and make comments for future episodes by using the Contact Us page on networkwestvirginia.com. You can also find us on Twitter at NetworkWV. And now the host of Network West Virginia's Legally Speaking, Amy Strobel.
Good evening and welcome to Legally Speaking on Network West Virginia. I'm Amy Strobel, joined by Brent Van Deysen of the Van Deysen Law Office, and tonight we're going to discuss protecting your home and assets through a trust agreement. Brent, welcome.
Welcome.
You have spent a great deal of time in your years as an elder care attorney learning about all the complexities of navigating the Medicare and the Medicaid systems. You've talked to seniors about their fears. You've seen the positive outcomes of seniors who've made really good decisions about their financial futures. And in turn, they receive wonderful nursing home care. And they also receive assistance with Medicaid and Medicare. So one way that you help seniors protect their assets and their home is through a trust agreement. What exactly is that?
Sure. So a trust agreement is a legal agreement that allows somebody to own assets for their own benefit from those assets, and that could be a home, that could be financial assets like stocks, bonds, CDs, annuities, savings accounts, anything like that. Pretty much anything that you yourself could own could go into a trust with a few exceptions.
Okay.
But the idea here is that the desire that many of my clients have is, while they're healthy, planning their affairs so that if down the road, 5, 10, 15 years from now, if they need nursing home care, they don't want to unnecessarily have to lose their home or their life savings if they can protect that. Now, people who are unfamiliar with appropriate planning strategies may have the opinion, oh, I can just put my children's name onto the deed to the house as a way to protect a home from a Medicaid lien. As I discussed in the last episode, though, that could have unintended consequences if the children then get in financial trouble. But when it comes to financial assets, the most common mistake that I see people make is adding a child onto a bank account or a CD, thinking that by adding the child's name onto the account, that is somehow going to protect that account in the event that the parent needs nursing home care, and that's not the case. When it comes to a financial asset like a bank account, they will presume that all of that money belongs to the parent and that the child's simply been added on as a convenience. So with a trust agreement as a planning option, we're looking to help seniors get peace of mind by planning their affairs in order, and there's essentially two categories, broad categories of assets we're looking to protect. The home. And remember, the reason for protecting the home is to protect it from a potential Medicaid lien. And then everything else is a countable asset. So that might be rental property, that might be farm property, that might be money in the bank in a savings account, a CD, money in an annuity, stocks or bonds, things like that. So what we're trying to do is, on the countable asset side of things, if somebody goes into a nursing home, to be able to, in advance, through a trust agreement, keep certain assets without having to sell them and turn them into a pile of money and then unnecessarily spend that money at a nursing home. So what is a trust agreement?
Yeah, yes. What is it?
I knew you were going to ask that question.
That was my very first main question, yes.
Sure.
What is it?
A trust agreement is a legal agreement that allows an individual, or if we have a married couple, to be able to create a legal agreement for the management of their property and financial assets. So if my name is Rose Smith, or if I'm a married couple, John and Rose Smith, we're setting up the Smith Family Trust as that legal agreement, and the trust is basically a legal agreement. It's a pile of legal paperwork created by an attorney for this trust to work for Medicaid purposes. It has to be irrevocable.
Okay.
And what that means is you are giving up the legal right to cancel the trust agreement and have the assets placed back in your name.
Okay.
Unfortunately, that is necessary in order to get the protections that are afforded. But there are plenty of still of options that the individual has. So if we're setting up a trust agreement, the person creating it is called the grantor.
Okay.
Then the other player involved is called the manager, or also known as the trustee. So if you're setting up a trust, you cannot be your own manager, you cannot be your own trustee, and your spouse cannot be a trustee.
Okay, because it's already sounding just a little scary, you know,
Sure.
to give up all that control.
Sure.
And, okay, this is why you need an attorney to do it. Don't do this on your own, right?
Well, and if you think about this, if you've added your children onto the deed to your home,
yeah,
you've made them joint owners.
so you've given up.
You've already given up control.
Yeah.
So instead, if we have a trust agreement, then I'm suggesting that people pick who the executor of the estate would be, have that person be the manager of the trust.
Okay, so somebody you trust.
Exactly.
Okay.
So, and for a family with children, that might be the oldest son or the oldest daughter, for example. And so we've set up for the Smiths, we've set up the Smith Family Trust. John and Rose are the creators of it. Their son Jim is the manager of it.
Okay.
We've done a new deed changing ownership of the property so that now the trust owns the home. John and Rose Smith maintain lifetime rights to live there.
Okay.
Right in the deed, it says life estate. That means that John and Rose keep their homestead exemption for tax purposes, so their property taxes remain low. They would still have to, pay the upkeep and maintenance and taxes and so on, just as they normally would. And they would have the lifetime right to live there.
Okay.
Nobody could disturb their ownership, and at their passing, if they were unfortunate enough to need nursing home care, and if the state paid for their care under the Medicaid program, because their lifetime rights end at their passing and the trust is the owner, then there's no right in the state to put a lien against the property.
Got it.
So the property is protected. In this case, the oldest son, Jim, is the manager of the trust. He doesn't own anything, and the trust document will say, at our deaths, or at my death if it's for a single person, then the trust ends. And then give my property to my son and daughter, Jim and Terry, and at that point, Jim is the manager of the trust after his parents' death, does a new deed, changing ownership from the trust to him and his sister Terry, and it's all done. The property's been protected. Now,
is a trust a will, or are those two different documents?
Those are two different documents. A will takes effect at your passing to distribute any property that you own that's not subject to another agreement.
Okay.
Okay?
All right.
But a trust, kind of sort of like a will, specifies those things owned by your trust and how they're distributed at death, just like a will would.
Okay.
Now, one nice thing about a trust, when we have your home owned through it, you can sell the home, so there's no barrier to that. If you've added your kids onto the deed as owners and you go to sell it, you would need their permission. But because they're owners, part of the money from the sale would belong to them. If they don't live there, there'd be capital gains taxes on their portion. What a mess. But when we have it set up through a trust, you keep your capital gains tax exclusion. You can turn around and sell the property. Now, the oldest child would have to cooperate in that sale.
Okay.
But some things about the trust, you know, what if that oldest child didn't agree? You have
one of these variables we always talk about.
You have the right to fire him and hire his little sister as the manager of the trust.
So this actually sounds kind of fun.
You retain more control than you realize because you have direct control.
Okay.
And I'll talk more about that here in just a minute.
Okay, yeah, let's go ahead and take a break. We'll be back in a minute with more on protecting your home and assets with a trust agreement. Stay with us.
Hi, I'm Brent Van Deysen. As an elder law attorney, my law firm is dedicated to helping seniors protect their property and their life savings from the high cost of nursing home care. My law firm helps seniors qualify for governmental benefits to pay for nursing home care, in-home care, and assisted living care. We can ensure that your life savings will benefit you and your loved ones, not the nursing home or the government. Call for a free consultation at 304-594-1900.
Welcome back to Legally Speaking on Network West Virginia. Brent Van Deysen and I are talking about protecting your home and assets through a trust agreement. And right before the break, we were having a little bit of fun about some of the changes you can make. Once you have a trust, the property that's in it and assets, it's irrevocable. That's in it. But you can still make some decisions and have some control. So let's talk more about that.
Sure. As I mentioned, when you set up a trust, you maintain the right to pick and choose your manager and can relieve them from their duties. And you know, maybe it's just that the person you picked as the manager, maybe your oldest child, has moved away from the area or has become busy and can't do whatever needs to be done. And then you can maybe appoint another child. But also, you know, a little bit of peace of mind if something happens where you need to make a change or want to make a change, like for example selling the home, and you need the manager's cooperation. If for some reason they didn't want to cooperate with you, no problem. You can relieve them of their duties and appoint somebody else. You even have the legal right to change the ultimate beneficiary. So if you have 3 kids, you've named all 3 as equal heirs, and then maybe one of those children hits the lottery and now doesn't need that portion of wealth. You could change the beneficiaries, or you know, if on a sadder point, if one of your children died before you, leaving children of their own, your grandkids, you could make a change to leave the deceased child's share to the grandchildren. So yes, even though the trust is irrevocable, meaning you don't have the legal right to get the assets back into your name, you still have the ability to, in this case with the house, sell the house, the money's paid to the trust, then find the next property, assuming it would be smaller. You know, downsizing is sometimes a concern. If you found the next property, the smaller property, now the manager of your trust, who's received the money from the sale of your home, now purchases the next home, and in that deed, you're going to be given lifetime rights. So in other words, the trust is flexible, so if you want to change ownership of the home, that's not an issue. So if you want to change who's going to ultimately benefit from that home by changing the beneficiaries, that's not an issue. And as far as the management of the trust, you know, and again, I'm going with, you know, picking the person who's going to be your executor. Chances are that somebody who's also a beneficiary of your trust, you know, they'll be most likely, in most cases, very happy to help, likely do it for free, because they know that they're going to eventually benefit from it as well. So then the other thing to consider putting into the trust would be those assets that would be countable and would have to be sold and the money spent before you qualified for Medicaid and nursing home care. So we want to look at other real estate which is not your residence. Because remember, you can own your residence, you can own a home, qualify for Medicaid, but then the state can go against it afterwards. So setting up a trust to protect your residence avoids the lien. But if you own other real estate that is not your residence, maybe you have a vacation home, maybe you have rental property, maybe you have hunting property, or that family farm you've inherited but you don't live there. All good examples of real estate which is not your residence, that if you own it and it has a value greater than $2,000, you find yourself in a nursing home, you're at that point, it's not your residence. Your only choice is going to be to sell it and get the money from it, and then spend that money, most likely spending it on nursing home care at that point. So if we've set up the Smith Family Trust for John and Rose Smith, and in addition to their home, if they had a 100-acre farm in Roane County that John had inherited from his parents, we do a new deed changing ownership of that 100-acre farm from John to Rose. Or maybe John co-owns that 100-acre farm with his brother because they both inherited it. John owns a half interest. Still, he would have to sell his half interest before qualifying for Medicaid in a nursing home, so John can convey his half ownership interest in that farm, so now it's owned by his trust. And then his trust agreement would say at his passing, or for a married couple, at their passing, who would then receive that half interest. Rental property. You know, you may have inherited your parents' home and just decided not to sell it, but are renting it out. If you own your own residence and then you own your parents' home, they've passed on and you're renting it and it's worth $60,000, if those are the only two things you own in this world and you wind up in a nursing home, before you could qualify for Medicaid, you'd have to sell that second home, turn it into a pile of money, and then spend that money.
And what about any renters then? Are they have to find a new place to go, I guess?
Well, I guess so.
Okay.
But
so it's a mess.
It can be.
It's something you want to avoid.
So if you have other real estate beside your home, or instead of your home, in addition to your home, having a trust to protect that real estate from a potential unwanted sale and spend down would be important. So then on the financial asset side of things, what we want to think about are those financial assets or that portion of your financial assets that you have identified as likely not being something that you're going to spend down, use and spend unless you had to. You know, maybe you know, you've got, say, $60,000 in a savings account. You haven't touched it in 20 years. You're comfortable living off of your income and have realized, I'm never going to touch that money. That would be an ideal source of funds to change the ownership of that savings account from your name to the name of your trust.
Because that way you still maintain a little bit of control over it, as opposed to gifting it or renaming it, because then it's just not yours anymore. Right.
Then the assets are sitting in your trust as opposed to being given to some other person who would then be free to spend those.
Them. Okay.
Yep.
All right, this is, and I feel like I say this on every show with you, but there are so many complexities, and every person has such a unique situation with different variables, and that's why it is so important to listen to our advice, but to contact an attorney who can deal with your specific needs.
And that's why I offer a free consultation to sit down with people, review their situations to determine, would this be an appropriate fit for them.
Great. Well, we're going to talk a little bit more about asset protection in just a moment. Stay with us.
Hi, I'm Brent Van Deysen. As an elder law attorney, my law firm is dedicated to helping seniors protect their property and their life savings from the high cost of nursing home care. My law firm helps seniors qualify for governmental benefits to pay for nursing home care, in-home care, and assisted living care. We can ensure that your life savings will benefit you and your loved ones, not the nursing home or the government. Call for a free consultation at 304-594-1900.
Welcome back to Legally Speaking. Brent Van Deysen and I are discussing protecting your home and assets with the help of a trust agreement, and we were actually just talking about assets, the financial assets. What do we need to know?
Sure. So on the financial assets, again, we're going back to the countable assets, those assets that you would likely have to spend down, before you could qualify for Medicaid paid nursing home care. So on the financial asset side, I gave an example of money sitting in a savings
Sure.
account. So the things that we're looking at putting in a trust, we're not looking at putting everything in a trust. Don't put your checking account in the trust. Keep a hold of that. Keep receiving your monthly checks, spending your money, paying your bills, just as you always do. Keep enough money on hand to make sure that any comforts are met,
Okay.
or if you wanted to buy a new car or something, that you'd have funds on hand to do that. But try to identify that portion of your wealth that maybe you've pretty well come to the conclusion that you're not going to have to reach in and withdraw that unless something happened, like you went into a nursing home and were forced to.
Okay.
So some examples of financial assets might be annuities. As interest rates have come down and people have found that money in CDs just aren't paying well, many folks have moved their invested assets over to annuities. So you might have put $100,000 into an annuity and are just letting it grow, or maybe you're just pulling the interest off of it. But if you've decided, hey, I probably would never need to withdraw the cash surrender value of that annuity, then let's do an ownership change, changing it from your name to the name of your trust. And the reason for doing that is, if you've put $100,000 into an annuity and it's grown to $130,000 and has a cash surrender value of $125,000, if you go into a nursing home, before you can qualify for Medicaid, you'd have to surrender that annuity and then spend down that money, $125,000.
Okay.
So why not change the owner of that annuity from your individual name to the name of your trust? The annuity would stay with the company that it's at. The pay-on-death beneficiaries for that annuity can remain the same, but we're doing an ownership change. So maybe you've got money in a CD. Maybe you've got $30,000 in a CD at your local favorite bank. You can change the owner on that account, let the CD remain there, but change the owner from Rose Smith to the Smith Family Trust, so that CD could remain there, but now the money that is in that CD, or with the annuity example, the cash value of that annuity is now owned by your trust. So if you wind up going into a nursing home down the road, you are not going to have to cash surrender those assets and then spend them unnecessarily on nursing home care, for example.
Okay. At what point do you start this discussion with an attorney about a trust? I mean, we get into a lot that you need a 5-year window and all that. Is this something you do when you're seriously looking into nursing home care, or is this something you do 10 years before?
You've got to do it. A trust agreement is not a magic way to get around the 5-year look back.
Okay.
Any sort of pre-planning, you need to be in reasonably good health with an expectation that you have at least 5 years of good health ahead of you to do any sort of pre-planning. Most people come to me with concerns of pre-planning probably about, I'd say at the earliest, right around when they get close to retirement age.
Okay.
And for everybody it's a little bit different. It's easier to make decisions on pre-planning for nursing home care the older that you are. If you're in your early 70s, have been retired for 7 years, it might be a whole lot easier to think about the realities of this as opposed to if you're in your mid-50s. And and several things may influence that decision. If you're in your mid-70s, maybe you've had a health scare that you've completely rebounded. Maybe your parent has just passed away after a long stay in a nursing home. So there are many things that will influence that. I've even had people in their early to mid-80s come in remarkably good health, longevity in their family, parents and siblings living in to the high 90s, low 100s, and it's not too late for them to do this kind of planning just because of their health history and genetic history as well.
Do you know, I'm putting you on the spot, do you know the average age that someone goes into nursing home?
I don't know the average age, but if you do a Google search for nursing home statistics, you will find that the percentage of people needing nursing home care, or the likelihood of needing nursing home care, increases each year with your age.
Okay.
And I saw one statistic that said if you're 84, then you have a 61% chance of needing nursing home care based on that age. And you know, statistics, they may or may not be very helpful.
Sure.
I think it's personal experience that tends to influence folks more than anything else. You know, if they had experienced a loved one going into a nursing home, it's easier to appreciate this than it may be for somebody who hasn't.
And speaking of doing Google searches, when I was researching this show a little bit, it was amazing when you type in trust agreement, a lot of websites or documents popped up that you could do it yourself.
Oh, yeah.
I have to ask you, because I know people like to save money and they think here's an easy way. Good idea or not?
The type of trust agreement that has to be set up for Medicaid planning purposes, it's really something only that a qualified elder law attorney is going to do. Most traditional attorneys who don't do elder law in their practice aren't going to touch something like this because the way you build the trust is unique. It has to be set up in such a way. Otherwise, if it's not set up the correct way, then what's in the trust could be a countable asset, and the whole purpose for it has been frustrated.
Okay, and you actually have a special accreditation, correct? Or this is for veterans. I'm thinking we're going to talk about it in our next show.
You're thinking about our next show, talking about the veterans benefits and the accreditation by the VA.
So you have to watch our next show for that. But yes, I did see you had that special accreditation. So basically, you just need to be careful online, filling out forms or trusting that information is your only source.
Yeah, I would not suggest by any means doing this sort of thing as a do-it-yourself sort of thing. You know, the reasons for having a trust agreement in this case are to potentially qualify for Medicaid down the road if you should need nursing home care. So how the trust is drafted, how the assets are titled, all of those things come into play as to whether or not it's appropriate to have a trust.
Okay, and if you need an attorney, here's your guy right here. Brent, as always, thank you for joining us tonight on Network West Virginia's Legally Speaking. We always invite our viewers to submit questions to Brent here at the station. Anything elder care law, it's his specialty. We hope to see you again soon. Good night.
You've been watching Network West Virginia's Legally Speaking. The views expressed on this show are that of our guest attorney and not the host, sponsors, or advertisers, and should not be considered as personal legal advice. If you have a specific legal issue, please speak with an attorney in person. For more information on schedules, appearing on, or sponsoring this or any Network West Virginia show, please use the Contact Us page on networkwestvirginia.com.
Hi, I'm Brent Van Deysen. As an elder law attorney, my law firm is dedicated to helping seniors protect their property and their life savings from the high cost of nursing home care. My law firm helps seniors qualify for governmental benefits to pay for nursing home care, in-home care, and assisted living care. We can ensure that your life savings will benefit you and your loved ones, not the nursing home or the government. Call for a free consultation at 304-594-1900.